Moving on, the Human Rights Court of the High Court Division on Thursday fixed July 21 to deliver its decision on whether or not to compel the Electoral Commission to furnish Henry Ernest Norway, who is Member of Parliament for Ashaman, with some procurement information. Originally, the court presided over by Justice Gifty Ejay-Ado was to deliver its decision on July 16, but adjourned the matter to July 21. Mr. Norway had gone to court in March this year to compel the EC to provide him with some information on the procurement of the new biometric management system, the BVMS. While the MP's action came after the EC had declined to furnish him with the information, stating that, quote, an applicant seeking to access information under the Right to Information Act shall pay the fee or charge approved by Parliament in accordance with the Fees and Charges Act 2009. Well, the Commission's case has been that the fees and charges applicable for the said information were yet to be determined in accordance with the law, hence the reason why I could not provide that information to the MP. Joseph Akablay, our court correspondent, joins us via Zoom with further explanations. Joseph, so what's the background to this particular story?
And so, it was one of the very first cases that was filed. In fact, it's in terms of the request when the Right Information Law took effect, one of the very first requests that was sent to any agency, in this particular instance, the Electoral Commission. It had to do with the procurement that had taken place that the MP felt he could rely on the law to ask for the documents pertaining to the process as to whether or not they went through the PP and got the necessary approvals for that particular procurement. And so he wrote to the Electoral Commission. He was waiting for a response. He got a response subsequently from them stating that they were unable to comply because of the failure by the state agencies responsible to fix the charges. And the point the MP kept making was to the effect that it's not his right as a citizen to ensure that those prices are fixed. And so once they've not been fixed, he cannot suffer the result of not getting access to information that he needs. And so once the law has come into effect, that cannot be an excuse for him not to get access to the information he requires. And so he took the matter over to the High Court, demanding that the court direct the EC to comply and provide him with that information, which he considers very important in terms of the electoral system and the electoral process that's already ongoing, and also to ensure that there's transparency in our governance structure, especially relating to elections as a whole.
And Joseph, what specifically will the court be determining at its next hearing?
So on July 21, the question to be answered is whether or not the EC's decision that they cannot provide information as a result of the unavailability of the prices relating to the cost of procuring that information, whether that decision is right. And so if the court were to rule that is right, then it means that you would have to wait for the prices to be fixed. But if that was not the case, then it means that the EC would have to provide him with the information. And he believes that that would determine his next line of action, that if indeed it appears that they did not follow the right procedure leading to the procurement of these devices, then there are some individuals who must answer questions.
Right. Joseph Akablay is our court correspondent, throwing some light on those details. Now